Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. First of all, I want to take the opportunity to thank both you as the attorneys and your clients for agreeing to participate with us via this Zoom argument. It's the best use of technology that we can make of it at this point in time. It's not what we would like, but because of the pandemic and because we're trying to keep everyone as safe as possible, it's our best solution to the problem. So thank you for participating. Having said that, though, let me remind you, you are both experienced practitioners, been to the appellate court before. We will follow the same rules and procedures as if we were all standing in the courtroom together. So please keep that in mind. What that essentially means is each side will get 15 minutes to make its oral argument. If you're the appellant and you've reserved time with Mr. Hibner, he will set the clock accordingly and you'll receive that time to make your rebuttal argument. Since we are doing this via Zoom, I do not anticipate any problems, but if we do experience some problems, what we'll do is just pause for a moment, figure out what we need to do, and we'll make whatever adjustments we need to. But I assure you, everyone will get the opportunity to make their argument within the time constraints that are allowed. Before we start today, let me introduce your panel. Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we call the case?
I know, Your Honor.
All right, sir. You may call the case, please.
Debra Sue Byington versus Jamie Reaves, D.O. et al.
We shall hear from the appellant.
May it please the court. Thank you, Judge. Your Honors, defendants have drawn what is a false equivalency, respectfully, between this case and the Potter and Foster cases, which equivalency ignores the fact and the factual differences between those cases and the case at bar. And the trial court erred respectfully in adopting that false equivalency. Ms. Byington's first complaint specifically disclaims any need for or connection to the pre-suit notices, which we mailed on her behalf the very day before filing the initial complaint. There was no disclaimer, however, that is mentioned like this in the Foster case, nor in the Potter case. Yet neither the trial court nor the defendants have really addressed this difference. Secondly, defendants also ignore the factual difference that in the case at bar, only the second suit, which we filed, referenced and attached a copy of those notices to the complaint. Whereas in the Potter and Foster cases, the pre-suit notices were apparently attached to both complaints in both cases. Likewise, in the case at bar, Your Honors, our second complaint, affidavits, as required under the Act, with exhibits demonstrating that we properly served the pre-suit notices on defendants. In our first suit, we did nothing like that. There's no indication in Potter or Foster of any such difference between the first and second filings in either of those cases. In Foster, in fact, the second complaint referenced such an affidavit, but the court noted that none was attached to the complaint. In both Foster and Potter, which were relied on by both defendants and the trial court in dismissing this case, the first complaints were the same as the second complaints, quote unquote, essentially identical, according to the Supreme Court in Foster versus Childs, actually. In the pending case before this honorable court today, that is simply not the situation. The first complaint averred that it was not making a Healthcare Liability Act claim, and specifically disclaimed any pre-suit notice or the need for serving or filing any pre-suit notices. The second complaint in our case didn't do any of that and also added an extra count for negligence. We submit that all of this requires reversal based on the face of the pleadings themselves of the trial court's dismissal on its own. And that's regardless, Your Honors, of Cooper versus Mandy or Franks versus Sykes, which also we believe apply to this case.
Let me ask you, Mr. Coughlin.
Yes, Judge.
You obviously sent the pre-suit notice within the statutory period and thereby got an extension of the statute for 4 months such that you could file a healthcare claim. If it was your intent ultimately to file a healthcare claim, what was the necessity of filing just a tort claim?
That's a good question, Your Honor. The reason we did that, and which may have led to all this confusion, I guess, is that we felt that with a regular tort claim, the statute would run before the 60 days had run following our following our giving of the pre-suit notices. In other words, for a regular tort claim, as you, I think you call it, to be filed within the statute of limitations, if it's not covered under the Act, then there is no extension for the regular tort claim, only for a tort claim which falls under the Tennessee Healthcare Liability Act when you've given the requisite notice, as you noted that we did. Does that make sense?
Well, I'm still trying to figure out. Obviously, you gave the notice, so I assume there was some intent within the 4-month period to file a healthcare claim. Why would you need to file a different claim?
First,
what were the damages going to be any different, Mr. Coughlin?
well, I guess we filed a different claim. If you're referring to a different claim being just an ordinary tort claim outside the Act, we felt that if we filed that after April 24th, I believe, then the 1-year statute would have run on such a plain battery claim or fraudulent inducement leading to consent, leading to a plain battery claim, because there would be no extension under the Act for the statute of limitations up to 120 days. I guess in retrospect, if we had given notice more than 60 days before the 1 year ran, then we could have filed these claims together as we did in our second lawsuit, Judge. But we didn't do that. So if we felt we were up against the statute of limitations for 1 year for an ordinary tort claim, even though the tort claims under the Act would have their statute extended, told under the Act's language once we sent the pre-suit notices.
Now, at the time you filed your second lawsuit, were you familiar with the court's holding in Foster?
Let's see, I'm trying to see my time. At the time we filed our first one?
Second one.
second
Time you
one.
filed your second lawsuit, were you familiar with the holding in Foster?
I believe that we were. Yes, Your Honor. And we just never thought that anyone would consider the pre-suit notices to be connected to or intended for the first lawsuit at that time. Otherwise, if we had, we would have sent a second set of pre-suit notices.
Well, if you didn't realize that was a problem, why did you immediately non-suit the first lawsuit if it was your claim that it was not a healthcare claim?
It was our claim that it wasn't. After filing the first one, but before filing the second one, it appeared that we might have been wrong about the first lawsuit not being covered by the act. In other words, that at that point, it appeared, this was before Franks versus Sykes was issued by the Supreme Court, and before Cooper versus Mandy, of course, issued later last year. It looked like perhaps we were wrong about the medical battery and the fraudulent inducement being not covered by the act. In fact, with the issuing of Franks and Cooper last year, it appears that respectfully that we probably were not wrong, but we non-suited it and just whether in the second act, assuming that everything would be covered under the act, the pre-suit notices would cover the second suit only, because in the first suit we said we had a disclaimer in paragraph 57 that we're not sending any notices. No notices are needed because we're not under the act. This is just an ordinary intentional tort. Does that help to answer the question?
Yes,
Judge
go right ahead.
Armstrong?
Yeah, go right ahead.
Okay. And I've reserved some time for rebuttal, but in a nutshell, what we're saying is that in addition to the plain language on the face of the pleadings, not connecting the first lawsuit to the pre-suit notices at all, is that Cooper clarifies that count one of our second suit, which is the case at bar, is not covered by the act. Instead, it states a claim for fraudulent inducement based on the defendant's business practices resulting in battery. And I believe my time for argument in chief is expired at this point.
Yes, sir, it has. Thank
Thank you,
you,
Honor.
and you have your rebuttal time. We'll now hear from the appellee. You may proceed.
Thank you. May it please the court, I'm Meredith Humbert on behalf of the defendants, appellees, Dr. Jamie Reaves and her medical practice, Caliderm. Dr. Reaves is a dermatologist practicing in Kingsport. Ms. Byington, in this case, mailed a notice of intent letter to Dr. Reaves and Caliderm on April the 23rd of 2019, which was 364 days after the mole surgery was performed to treat Ms. Byington's skin cancer. Dr. Reaves and Caliderm both received the notice of intent letter from Ms. Byington 2 days later, which was April the 25th of 2019. 4 days after they received that notice of intent letter, they were then served with a lawsuit that had been filed by Ms. Byington, and the service was on April the 29th of 2019. Dr. Reaves and Caliderm filed a motion to dismiss their original complaint on the grounds that Ms. Byington had failed to comply with the requirements of the Tennessee Healthcare Liability Act by not waiting 60 days to file her complaint after sending the notice, and also for her failure to file a certificate of good faith with that original complaint. Ms. Byington did not file any opposition to the motion to dismiss. Instead, Ms. Byington exercised her right to voluntarily dismiss the original action, and an order of voluntary dismissal was entered by the trial court on June the 19th of 2019. Approximately 2 months later, after the original complaint had been dismissed, Ms. Byington filed a second complaint on August the 16th of 2019. Of great significance, Ms. Byington did not send a notice of intent letter to Dr. Reaves and Caliderm following the dismissal of her original complaint and prior to filing the second complaint. A motion to dismiss the second complaint was filed by Dr. Reaves and Caliderm, and the grounds was that Ms. Byington's failure to send notice of intent to Dr. Reaves and Caliderm following the dismissal and prior to filing the second lawsuit.
Let me ask you, you represent the defendants in both of those lawsuits, is that correct?
Yes, Your Honor.
And you knew from reading the first complaint, they said in paragraph, I think it was 46, that they didn't send a pre-suit notice. And the reason they didn't, they claimed they were not filing a healthcare claim. In their second lawsuit, they specifically refer to the earlier pre-suit notice, and they also provided a certificate of good faith, which they're required to under the Act. And I know with your first motion to dismiss of the first lawsuit, you filed that almost immediately within a month of the filing of the complaint. But in connection with the second lawsuit, you waited almost 8 or 9 months before filing a motion to dismiss. If you thought Foster applied, and this was a successive filing of a healthcare claim, and we know in the Foster, for each filing, you have to file a pre-suit notice. Why did you not immediately file a motion to dismiss? Is that because you thought Foster didn't apply, Ms. Humber?
No, Your Honor. We believed Foster did apply the entire time that second case was pending. We waited because we relied on the Court of Appeals holding in Blankenship that you don't waive your argument by not raising it immediately. And we also wanted to ensure that the case could not come back for a third time.
So you waited for the expiration of the 120 days?
Yes, and we waited until a year had passed after the dismissal of their original lawsuit.
Okay.
Your Honor, the disclaimer.
But let me ask you, if they say in the first lawsuit, we're not sending you a notice, notice doesn't apply. But in the second lawsuit, they say the notice they sent you in April applies to that lawsuit. Why does that implicate the Foster holding?
I think the Foster holding applies anytime that a patient or a patient's spouse, if it's a wrongful death case, files a healthcare liability action against a provider. The first complaint and the second complaint, maybe they're not identical, but they're strikingly similar in the language that's included when you compare the two. The disclaimer referenced by Ms. Byington is included in paragraph 57 of the original complaint. And it states that because her claim is for battery, not negligence, it was not necessary that the defendants be served with a notice of potential claims 60 days before the suit was filed. Ms. Byington attempts to convince this court that by including that statement, she effectively disclaimed application of the Tennessee Healthcare Liability Act's notice of intent requirement. In her reply, Ms. Byington claims that even if both of her complaints were subject to the Tennessee Healthcare Liability Act, that Dr. Reaves and Caliderm should have known that the notice of intent that they received did not relate to the first complaint. I think this argument fails for a couple of reasons. First, it mistakenly assumes that Dr. Reaves and Caliderm should have assumed that a second complaint would be filed against them. Dr. Reaves and Caliderm received the notice of intent letter prior to being served with the original complaint. Consequently, it was logical for them to assume that the notice of intent related to the lawsuit that had been filed against them. They had absolutely no way to know that Ms. Byington intended to file a second complaint. Ms. Byington's argument also fails because it mistakenly presumes that a party to a case has the ability to control whether a law applies. A party can obviously present arguments as to why a law should or should not apply in a case, but ultimately, it is the courts of this state that decide whether a law is applicable. Whether or not Tennessee Code annotated 2926-121A1 applied to her original complaint is not for Ms. Byington to decide, or for her to have the ability to disclaim. If a party were permitted to pick and choose the laws that can apply to a case, I think an abundance of plaintiffs would likely begin disclaiming application of the statute of repose.
Doesn't it make a difference as to whether or not the cause of action in the original complaint was in fact a healthcare liability claim?
I think if it's a healthcare liability claim, which we believe it was, you don't have the ability to disclaim the pre-suit notice requirement.
No, I understand, but my question is, if it's not a healthcare liability claim, if it's just an intentional tort that is not a healthcare liability claim, it may have arisen out of the same set of operative facts, but but based on existing case law, is not a healthcare liability claim. Would you take the same position that the new notice would need to be filed with a second complaint that was a healthcare liability claim? Clearly a healthcare liability claim?
I think that makes me think of the Lacey decision, where they had a battery and then a healthcare liability action. And
that was in the same case, though. That was in the same case.
Yes.
Right. In Lacey, you had a healthcare liability claim and a battery claim, and we held that it was not required on the battery claim. My question here, though, is, as I understand the position of the plaintiff's taken the position that the first complaint that was filed was not a whether they had the disclaimer or not. And I understand your position on that. But my question to you is whether, in fact, that if that claim was not a healthcare liability claim and was, regardless of the disclaimer, and was in fact a battery claim, like as in Lacey, for which there was no need to file the notice or the certificate of good faith, is there any reason why the certificate of good faith and the healthcare and the notice could not apply to the second case, which was a healthcare liability claim?
Your Honor, respectfully, I think the better practice would have been to reissue the notice letter after the dismissal. I'm not sure that issue has been decided by the court. I think that if it were a true medical battery, like occurred in Lacey when the chiropractor hit the patient on the back with a folder as he left the exam room, then maybe a notice wouldn't be required for that. But our case does not involve a battery. It can be called a battery, but it involves a healthcare service to a patient. It involves discussions between a patient and a physician regarding what type of medical treatment is medically indicated to treat skin cancer.
So the position based, that's really what I'm trying to understand. The position that you're taking is that, in fact, because I think this is distinct from the position the plaintiff's taking, and that's what I'm trying to get to, is that, in fact, the first complaint was a healthcare liability claim.
Yeah, yes, Your Honor. And that's how we briefed our original motion to dismiss.
Because regardless of I agree with you, regardless of the disclaimer language, the question really is whether, in fact, it was a healthcare liability claim or not. As I understand the plaintiff's position, they're taking the position that it was not a healthcare liability claim. You take the position that it was a healthcare liability claim. It seems to me that that's an important distinction.
Yes, Your Honor, I would agree with that. And we think that the record's clear that it was a healthcare liability claim because some of the allegations by Ms. Byington against Dr. Reaves involve things like the standard of care required Dr. Reaves to offer radiation therapy as an alternative treatment. And that language is included in the original complaint. And that sounds much more like an informed consent healthcare liability action than it does a battery. Medical services were ongoing. There was a physician-patient relationship in place. These are all distinguishing factors from the Cooper decision.
Thank you. I think you've answered the question. Thank you very much.
Okay. I think that we distinguish this case from Cooper because of the fact that there was a physician-patient relationship and because the pending action, the original complaint, clearly involved claims by Ms. Byington that directly involved the provision of ongoing medical services. And the order of dismissal entered by the trial court specified that it involved claims relating to medical services. And so I think the record's clear that this was a healthcare liability action, not a battery claim when it was originally filed. It's the position of Dr. Reaves and Caliderm that the application for permission to appeal in Cooper, because I know that in Cooper, the defendants have filed an application with the Supreme Court, and I believe that was filed on January the 19th. We filed our brief 2 days later, and I want to apologize because I think we included a footnote on page 17 that said an application had not been filed at the time of filing the brief. And I want to tell the court that I did check the AOC's website at least the day before, and I apologize for that error. But regardless, we don't think that the pending action involves a business practice. We believe it involves a professional healthcare service provided by a physician to a patient. The trial court followed the Tennessee Supreme Court's holding in Foster versus Childs and dismissed Ms. Byington's second complaint for her failure to provide notice of intent to Dr. Reaves and Caliderm following the dismissal of her original case and prior to filing the second complaint. We believe that the trial court got it right when they dismissed the second complaint.
Let me ask you, in Foster, it's clear that the plaintiff was filing a healthcare lawsuit, both the first case, second case. In our case here, the plaintiff is saying, I didn't file a healthcare case, so I didn't send a notice in connection with it. Does that make a difference? Or are you saying if we find that it was a healthcare case, that we somehow connect that notice to that first filing? And it doesn't matter that the plaintiff in filing their lawsuit don't connect that notice to the first filing and connects it to the second filing.
Yes, Your Honor. I think that if this court holds that the original action was a healthcare liability action, then the notice of intent necessarily applied to that first case. It was sent out the day before the original case was filed, and it was received by Caliderm and Dr. Reaves prior to when they were served with the original complaint. So I believe it does relate back. In conclusion, Dr. Reaves and Caliderm believe that the trial court was proper in its dismissal of Ms. Byington's second complaint due to her failure to provide notice of intent to Dr. Reaves. And therefore, we'd request that this court affirm the ruling by the trial court.
Thank you, counsel. We will now hear from the appellant in rebuttal.
Thank you, Your Honor. I'd like to clarify our position in response to Chancellor Golden, or Judge Golden's question to defense counsel. We are saying that regardless of whether this court considers our first complaint to be partially or entirely covered by the act or not, that the plain language of our first suit clearly disconnected any possible connection to the pre-suit notices, which were not received until after our first suit was actually filed by the defendants when we served them with process. So we did not intend our first suit to be a case under the act. As Judge Armstrong pointed out under paragraph 57, it says, since this complaint is based on the tort of battery, not negligence, it was not necessary to be served. So we respectfully submit that in the light most favorable, especially in the light most favorable to the plaintiff, that is very clear, and that we
Let me make sure I understand this. You send out notice of a healthcare liability complaint, and then you file a complaint, and it turns out, in fact, that it's not a regular tort claim. It in fact may be is a healthcare liability claim, has counts in it that are a healthcare liability claim. So, and it's your position that you can disclaim the notice that you've sent immediately preceding the filing of that healthcare liability claim, and say that this notice doesn't apply to this complaint? Is that what you're saying?
Yes, Your Honor. That we are saying that. We're not saying that we can change that we can with one disclaimer change what this court included, determine that first suit was or wasn't. But we are saying that based on the plain language of the pleadings in that case, especially compared to the plain language of the pleadings in the second suit, as I think Judge Armstrong has contrasted somewhat already today, that there could be no question, or there should be no question, that our pre-suit notices were intended only for the second suit and never for the first one.
But are you saying a court can't look at what you've pled and determine whether or not it's a healthcare liability claim, or whether or not it's a simple tort claim, or you can just disclaim all that?
No, I think the court can determine that it actually sounds in one or the other. But I think that that determination isn't necessarily determinative of which suit the pre-suit notices were connected to and sent for. Does that make sense?
Let me ask you, Mr.
I don't think you want my response to that.
Okay.
Mr. Coughlin, you have conceded that the first lawsuit was a healthcare lawsuit. Is that right? Is that the
We did
conception?
reluctantly concede that at argument in the trial court, Your Honor.
So you have conceded that?
We did.
Okay.
I don't know that it's
right.
correct. I don't know if that was the correct concession or not, based on Cooper now. And I realize that it's pending application to the Supreme Court, but
you didn't have
that's
the
where we are
benefit of
now.
Cooper when you made the concession, did you?
I did not.
Yeah. All right.
Absolutely not.
All right. Thank you, counsel. We appreciate your arguments. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We again appreciate you participating via Zoom. And having said that, Mr. Hibner, anything we need to take up before we recess court for the day?
No, Your Honor.
All right, you may recess court then.
This honorable court is now adjourned.
Thank you, Your Honor.
Thank you, Your Honors.
Thank you, counsel.